Welcome back to IChatLaw, the podcast where we untangle the real Canadian legal system, one myth at a time. Hollywood has made the movie industry and the legal industry quite interesting. My name is Käsh. Today, we are putting on our myth-busting hats. Imagine it here. Taking aim at one of the biggest source of legal confusion out there. Courtroom dramas, especially the Law and Order type of franchise. Shows like the Law and Order, CSI, even Suits, they're all incredibly entertaining. But let's be honest, they often play fast and lose with the law. Especially Canadian law. They blur jargon, simplify complex procedures, and sometimes just plain get it wrong, leaving viewers with ideas that just don't hold up in any Canadian court proceedings, for example. And these myths are just harmless fun, right? Well, believing them can lead to misunderstanding about your rights, unrealistic expectations of the justice system, and even anxiety if you find yourself involved in it, making reference to the wrong legal principle. So today we are going to try and look at some of those principles and how that can impact the way you consume legal services in Canada. Let's start with the myth number one. I plead the fifth. Well, that dramatic moment where a suspect climbs up invoking, I plead the fifth. The magical incantation, I plead the fifth, implying total silence without consequences. Well, let me be clear. Canadian reality is different. There is no Fifth Amendment in Canadian legal proceedings. Our rights against self-incrimination comes from Section 13 of the Charter of Rights and Freedoms, protection against use of your testimony in subsequent proceedings, and Section 11C of the Charter of Rights, rights to be not to be compelled to be a witness against yourself in any criminal proceedings, are the rights that Canadians ought to assert. Nothing more, nothing less. Here's the key difference, folks. In Canada, you absolutely have the right to remain silent upon arrest or detention. Charter Section 10B provides that right. Police must inform you of that right and your right to speak to a lawyer. But saying I plead the fifth just confuses everyone. Simply state, I wish to remain silent and speak to a lawyer. That's it. Silence itself generally cannot be used as guilt or evidence of guilt at a trial, unlike in some very specific US TV context that tends to exaggerate these things. The myth number two is it's my right, free speech, the absolute version of it. Well, let's set a scene. Characters is protection online or in any capacity keep screaming, it is my right to make hateful, threatening, or defamatory words without any consequences. That is not the same in Canadian legal proceedings. Canadian reality is different. Freedom of expression is protected under Section 2B of the Charter of Rights, but it's not absolute. Hate speech in Canada is not protected. Defamation, uttering threats, obscenity, and promoting terrorism, all examples where free speech can be restricted or punished. Your free speech doesn't give you carte blanche to cause any harm. And that's the Canadian way. Americans have it differently, but we're talking the Canadian way. As a Canadian or somebody who's interested in consuming Canadian legal services, you ought to be aware of that. Myth number three, that is, read me my Miranda Rights. The setting in one of those TV shows, usually arresting officers flawlessly recites the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you. Yada, 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 yada.
All right, Mr. DeBoer, I'm going to read to you your Miranda rights, okay?
Mm-hmm.
All right, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned.
Canadian reality is quite different. There is no standardized Miranda script in Canada. The requirements simply stems from Section 10B of the Charter of Rights. The right to be informed of the reasons for your arrest or detention, the right to retain and instruct counsel without delay, and the right to be informed of that right. In other words, you have the right. There's no need to get through any somersault in order to exercise. You just have to assert your right. Make sure that it's clear that you understood it. And if you don't, always remain silent. Don't start just yapping. It won't help you. And police cannot force you to speak or give evidence against yourself. The police must inform you of your right to have a lawyer and give you a reasonable opportunity. And that's a reasonable opportunity to contact your lawyer. That's reference case Bridges. They must also tell you that there's legal aid available if that's one. The wording varies from police service to another, but failure to properly inform can lead to evidence like statements being excluded. So it is wise for law enforcement to ensure that they have properly informed whoever is being held under police detention for purposes of investigation or allegations of criminal behavior. Now let's look at some of the other myths, and that is fruit of the same poison tree, which means that all evidence is tossed if it's coming from a bad source or a source that is not reliable. So, for example, like not getting a warrant leads the judge to dramatically throw out all evidence, resulting in a guilty person walking free. That's a Hollywood sort of depiction. Canadian reality is quite different. The exclusion of evidence obtained via a charter breach is governed by Section 24(2). The test is, would admitting the evidence bring the administration of justice into disrepute? In this particular instance, the court must consider what the seriousness of the breach would be on the accuser's right, society's interest in an adjudication on the merit. So that's what is usually referred to as a public interest argument. It is so, in particular, if one were informed that they needed a warrant and one deliberately just said, no, we don't care, we don't need a warrant, that's a problem. But what if the warrant was obtained with some technical error? The court will weigh all of that and see where the balancing act in terms of the seriousness of the breach, the public interest, and the need to resolve the matter. So, TV shows like that can be confusing. Don't let that confuse you. It is important to know what really actually works and is applicable in the Canadian jurisdiction, or especially if you're someone who have a matter within the Canadian legal context. Now let's look at the myth number 5. Myth number 5 is you get a phone call, right? The newly arrested character demands that there one phone call, usually to a lawyer or a loved one, to be arranged or to arrange for bail. But the Canadian reality is quite different. There is no legal limit of one phone call. The right is Section 10B of the Charter is to retain and instruct counsel without delay and to have a reasonable opportunity to do so. This generally means privacy and enough time to actually reach and consult with a lawyer. You might need multiple calls to reach someone. So definitely the Canadian legal scene doesn't have that one phone call that usually you see in dramatic TV shows. It is absolutely meaningful opportunity, not just a single call quota. So this is very important. Let's deal with myth number 6, beyond a reasonable doubt. Beyond a reasonable doubt means absolute certainty. Let's play the scene out. Lawyers argue that beyond a reasonable doubt requires the jury to be 100% certain, leaving no room for any question whatsoever. Is that the case? Well, the Canadian reality is that the Supreme Court of Canada has clarified this repeatedly in Lickfuss, R versus Lickfuss, which says a reasonable doubt falls short of absolute certainty. It means that the evidence must be so convincing that you feel sure about the accused's guilt. A reasonable doubt is based on reason and common sense, logically arising from the evidence or lack thereof. It is not a far-fetched or a frivolous doubt in this particular case. Juries are instructed that it's a high standard but achievable based on the evidence presented. Requiring absolute certainty would make convictions, yes, nearly impossible, right? So, but it just has to be reasonable, i.e. reasonable and beyond doubt. Time served equal freedom at sentencing. Well, the TV characters usually spend months in jail awaiting trial. At sentencing, the judge dramatically says the time served and they walked away free. Is that the case? Is that always the case? Is that a reflection of the reality? Canadian reality, in this case, time spent in pre-custody trial, that time is absolutely credited to sentencing, often an enhanced rate, i.e. 1.5 or 2 days credit for each day that was spent due to the hard conditions. But the judge must still impose total sentence that fits the crime. If the appropriate sentence is 3 years, for example, and the accused has spent 1 year of enhanced credit, equivalent to 1.5 years, they're still required to serve the remaining 1.5. Time served only means immediate release if the credit equals or exceeds the total appropriate sentence. In other words, those dramatic moments where people go, oh yeah, you're free to leave, it's not always the case. Credit, necessarily or get out of jail card credit, it's real. However, it's within the context of what is reasonable, which is exactly how the Canadian jurisprudence interpret those rules. Now let's tackle myth number 8. Myth number 8 deals with lawyers can withhold evidence if it hurts their case. A defense lawyer discovers evidence proving their client is guilty and agonizes over it, whether to disclose it or to bury it. Canadian reality? Well, let's look at the Canadian reality. Defense lawyers have a positive ethical obligation, that's R versus Stinchcomb, to disclose all relevant evidence in their possession to the Crown before trial, even if it's harmful to their client's case. This includes evidence that could prove innocence or guilt. Failure to do so is a serious breach of ethics and professional conduct rules and can lead to mistrial or other sanctions by the Law Society, for example. The adversarial system requires a level playing field based on full disclosure. Defense counsel cannot ethically suppress evidence that shows guilt. Their role is to ensure a fair trial, and to win at all costs by hiding the truth is not allowed, or it's not permissible. Myth number 9. We're almost close to the last two myths. And this is where I would like to say I appreciate you for being part of the show. Thank you for engaging and being here. If you find value in this, please like and subscribe and share. And thank you again for being part of the show. Now let's get back to the last two myths. Number 9 myth, you see that dramatic Perry Mason confession sort of type of scene. The defense lawyer, through brilliant and aggressive cross-examination, tricks the real killer into breaking down and confessing on the stand. Perry Mason type of legal drama.
Did you not kill your husband?
Yes. Yes. Yes.
You didn't kill Thompson. But you did, Mr. Wells.
Yes.
Canadian reality is quite not the same. While compelling courtroom drama moments do happen, spontaneous confessions under cross-examinations are incredibly rare. Real trials involve preparations, strict rule adherence to the rules, hearsay opinions are not allowed, cross-examinations that exposes inconsistency or weakness in testimony, not to produce fabricated confessions, but just, to literally get to the truth of the matter, are usually the norm, right? It's a gradual process that unfolds, and people are cross-examined, and then their evidence are weighted on the basis of that. So those dramatic confessions that you see in Perry Mason type of shows are not always and hardly the case. The police need a warrant for everything. Myth number 10. No, that's not true. You can see in the scenes, detectives constantly fret about warrants, implying one is needed for any investigative step within their law enforcement work. The reality in Canada is different. The Criminal Code and Section 8 of the Charter are all required for any significant intrusion on privacy. For example, searching people's homes, private computers, lengthy bodily samples. However, police have significant powers without a warrant in many situations. And this is some of the potential situations where police can conduct their police work without a warrant in Canada. So, police can search persons within immediate control for safety or evidence, i.e. preservation of public security, right? This is important. This is important. This is one of the reasons why sometimes, even if you're being searched and you say, I do not consent to the search, it is important because ultimately, if the whole search process is being reviewed and it came out that you exercise your right not to be searched and you're still searched, the court would take that into a consideration in terms of the validity of that search. In certain regulatory contexts like border searches, impaired driving checks, the police doesn't need warrant to check whether or not you are impaired you were impaired while driving. The key is reasonable expectation of privacy. Warrants are crucial for high privacy areas, but police aren't paralyzed without one for every action. It all depends on the context of within which the matter is being investigated or being attended to. So, wrap it up. Why does all of this matter? Why does busting these myths actually matter beyond just being pedantic in this case, right? Because I submit to you that because misunderstanding your rights can have real consequences. Thinking you can plead the fifth might lead you to say something harmful without properly invoking your right to silence and to counsel. Believe in free speech is absolute. Could land you in a legal trouble more than you can imagine. Thinking police always needs a warrant might make you resist when actually they have the power, and ultimately might lead to escalation. So exactly, TV simplifies and dramatizes these things, but the Canadian legal system is a complex, nuanced, and rooted in our unique charter and common law traditions. It prioritizes fairness, balances, and proportionality, often in very different ways than the U.S. systems, or as portrayed in those U.S. shows. But remember, they are fiction. If you have a real question or concerns, consult a qualified Canadian lawyer or a reliable legal resource, and speak to somebody who actually understands the Canadian legal landscape. This is a good point. This is a good time to tell you that everything we provide on this show is for educational and reference purposes. This should not be construed as legal advice. If you need a lawyer, contact us or speak to a local lawyer within your community or your area, and they'll be more than happy to help you. Like I said, if you need help, drop us a comment, and we will try and get you in touch with somebody who actually knows how to help you in your particular case. So remember, remaining silent during an investigation, the expectation that your right to say anything without any consequences, it's not an absolute one. It's governed by some kind of reasonable limits and restrictions, and all of which allows us Canadians to have a reasonable, fair, and a very, very practical legal jurisdiction. Until next time, this is IChatLaw. Stay informed, and remember, we are here to assist and to help you get access to justice. If you need more information, reach out to us, and we'll be more than happy to help you. See you on the next one.